This is Chapter 3, the U.S. Legal System and Alternative Dispute Resolution, Part 1, presented by Kelly Herzik. In this first half of Chapter 3, we're going to be discussing the U.S. court system, jurisdiction, two types of jurisdiction, personal, which is also called in personam jurisdiction, and subject matter jurisdiction, venue, and then we will discuss the state court system, its overview, the structure, and then we'll go through the Kansas courts, the District Court, the Kansas Court of Appeals, the Kansas Supreme Court, and finally, Kansas Judicial Selection. We will begin with the U.S. court system. As we learned in Chapter 1, the U.S. Constitution is the supreme law of the land in the United States. And as a reminder, it creates a federal system of government in which power is shared between the federal government and the state governments. Due to federalism, both the federal government and each of the state governments have their own court systems. Article 3 of the Constitution governs the judiciary. We've already covered that, so you should remember that concept. The primary difference between state and federal courts is one of jurisdiction. Jurisdiction. What is jurisdiction? The simplest definition is that jurisdiction refers to the types of cases a court is authorized to hear. Basically, a court has to be able to both hear the case and render a binding decision. State courts are courts of general jurisdiction, which means that they are generally authorized to hear all types of claims, including those that arise under either federal or state law, though there are exceptions where federal courts have exclusive rather than concurrent jurisdiction with state courts. We will discuss what exclusive and concurrent jurisdiction is later in the presentation in Part 2 when we discuss federal courts. But the biggest issue here that you need to remember is that state courts are courts of general jurisdiction, meaning they can pretty much hear any types of claims except those ones that are specifically reserved only to federal court. Federal courts are courts of limited jurisdiction, meaning that they only hear the types of cases authorized by the U.S. Constitution or federal statute. That means that unless they are specifically authorized to hear it, federal courts cannot hear it because they are not courts of general jurisdiction. Trial courts are courts of original jurisdiction, meaning they have the power to hear cases when they are first filed in the legal system. Plaintiffs have the option to choose where they want to file cases. They can file in state court or federal court if they're allowed to file in federal court, if the federal court will have jurisdiction. But trial courts is where they have to start. Those are the courts of original jurisdiction. In state court, if they decide to file in state court, these courts are often called county courts or courts of common pleas. For example, here in Wichita, we have the Sedgwick County District Court in the 18th Judicial District of Kansas. Most of the time, if I'm going to file a case for a client here in Wichita, I'm going to file in Sedgwick County District Court. Federal trial courts are called federal district courts. For example, the District of Kansas Federal District Courts are located in Wichita, Topeka, and Kansas City. We have one district, the District of Kansas, but it's located, they have offices in Wichita, Topeka, and Kansas City. Some states like Texas have more than one. In fact, Texas has 4 districts. They have the Eastern, Northern, Southern, and Western. But Kansas only has the one, the District of Kansas. Appellate jurisdiction refers to jurisdiction of an appeals court to hear an appeal. Appeals courts review the decisions of the lower trial courts to determine if judicial decisions rendered below were in error. Case goes to trial in district court. Suppose you lose, but you think you lost because the court made an error. You can appeal the decision at the trial court to an appellate court. Appellate courts do not decide facts and do not hold their own trial. Rather, they review the factual record from the trial court and the appeal briefs the legal arguments of the parties. They may also hold oral argument and question the parties' counsel. An appellate court is not a second bite at the apple. You have the facts that were developed at the trial court, and then they go up to the appellate court. The appellate court is bound by those. Their job is to see whether or not basically the trial was fair. Did you have a fair trial? Or were there errors in the trial necessitating a reversal of the trial court? Now let's talk about personal jurisdiction. A court must have jurisdiction over the parties to a lawsuit and its subject matter to render a binding decision. So even if you start in the right court, if you start in a court of original jurisdiction in the trial court, that trial court still has to have jurisdiction over the parties and its subject matter to render a binding decision. So we're going to start with subject matters over the parties, which is called personal jurisdiction. It's called in personam jurisdiction, literally jurisdiction over the person or party, is the court's power over the parties before it. It is limited generally to the court's geographical region. For example, a Kansas state court's jurisdiction extends to its state's borders. Federal district courts are limited to their geographic region. Kansas only has one federal district court, though it has 3 locations, so its jurisdiction is also the state of Kansas. A court acquires jurisdiction over a matter when the plaintiff or complainant files a lawsuit. It starts with the plaintiff's complaint or petition, which sets forth the factual and legal claims the plaintiff is making and the relief he or she is seeking. The court acquires jurisdiction over the defendant or the respondent when the defendant is served with service of process via a summons. That provides a copy of the complaint and instructions on the requirements for a response to the complaint. Service is made based on state court rules. Usually it has to be in person, a service processor hands you the subpoena, or by mail, certified or regular mail. Some states also allow email service, residential service, which is leaving the service of process with an adult at the location, service on the state attorney general, or even service by publication in the newspaper, although that's fairly rare. While acquiring jurisdiction over in-state defendants, people who live in the state, are usually easily accomplished based on the state service rules, it can be more complicated acquiring jurisdiction over a party who lives out of state. There are procedural rules for service of out-of-state defendants. Most states have long-arm statutes to reach and exert jurisdiction over out-of-state defendants that have sufficient minimum contacts with the state, such as an out-of-state business that regularly does business in the state seeking to exert jurisdiction. This comes from a famous Supreme Court case called International Shoe Company versus Washington. It was decided in 1945, and it has real staying power. The Supreme Court in that case held that an out-of-state company can be subject to jurisdiction in a state, even if they don't have a headquarters or a physical presence in that state, if it has sufficient minimum contacts with the state. An example would be a Missouri business that doesn't have an office in Kansas that regularly sells products to Kansas residents. That Missouri company can expect to be called into court in Kansas if there is a dispute with one of its Kansas customers over the product's warranty, or if the product causes a personal injury in Kansas. Sometimes a plaintiff may not need or want jurisdiction over an out-of-state defendant, but because the person has property in the state, the plaintiff may seek to file suit against just the property and not the person. This is called in rem jurisdiction, which literally means in Latin, jurisdiction over the thing. It's often used by state and local governments to file suit to seek unpaid property taxes by seizing the property and selling it at auction to recoup the taxes. Mortgage companies and banks also use in rem jurisdiction to foreclose on the property, though they also try to sue the debtor personally on the debt as well. Now let's discuss subject matter jurisdiction. In addition to jurisdiction over the parties before it, like we just discussed, the court must also have jurisdiction over the subject matter of the lawsuit. Subject matter jurisdiction gives the court the power to hear the types of cases presented to it. Now, there are some claims that must be brought in federal court only. Remember, as we discussed, state courts are courts of general jurisdiction, meaning they can hear pretty much every case, right? The exception are the federal jurisdiction cases only. There are certain cases that you cannot bring in state court that you must bring in federal court. Federal court has exclusive jurisdiction over those cases. These issues are admiralty, which is law of the sea cases, bankruptcy cases. You can't file a personal bankruptcy, for example, in state court. You must file it in federal bankruptcy court. Federal criminal cases. The government of the United States does not file their criminal cases in state court. They file them in federal court. State versus state cases. Very, very rare. Suppose Kansas sues Missouri over water rights. Those aren't heard in state court. Those are exclusively heard in federal court. Claims against the United States must be heard in federal court. Patent, trademark, and copyright cases are also exclusive federal cases. And federal statutes that explicitly provide for exclusive federal jurisdiction. There are some statutes that have within the statute itself a jurisdictional component. They're pretty rare, but there are a few statutes out there that do provide that the only place you can file suit under the statute is in federal court. The state court system is, of course, a broad system of justice. They're courts of general jurisdiction, as we discussed, meaning they can hear most claims except those that are exclusively federal, the list of which was on the previous slide. However, on the other side of the coin, there are some exclusive state court jurisdiction matters, primarily dealing with family law. For example, divorces and adoptions must be filed in state court. You can't get a divorce or adopt a child in federal court. There are instances where subject matter jurisdiction falls within both state or federal court. This means that a plaintiff can bring their claims in either federal or state court. The plaintiff is the captain of their ship when it comes to filing their complaint. They're the ones who choose where they want to start their court case. This is known as concurrent jurisdiction between federal and state court. It's basically overlapping jurisdiction. It means that you can bring it either in state or federal court, and it's the plaintiff's choice. State and federal court jurisdiction overlap when the claims present 1, a case concerning a federal question, or 2, there is diversity of citizenship between the parties, meaning the plaintiff and the defendant are from different states and the amount in controversy is over $75,000. To bring a lawsuit in federal court under concurrent jurisdiction, the plaintiff's claims must present either a federal question or the parties to the lawsuit must be completely diverse. But what does that mean? What is a federal question? A federal court can hear a civil case because the plaintiff has alleged a violation of the United States Constitution, federal law, or a treaty to which the United States is a party. For example, a Kansas plaintiff alleges a violation of the Fair Debt Collection Practices Act, a federal statute. She's alleging that a Missouri debt collector improperly collected the debt in violation of the Fair Debt Collection Practices Act. Plaintiff can bring her lawsuit in this case in federal court under federal question concurrent jurisdiction because she's alleging a violation of a federal statute, the Fair Debt Collection Practices Act. Under federal question jurisdiction, there is no monetary minimum that must be alleged. The key is whether or not federal law is involved. Plaintiffs can also bring cases in federal court under diversity jurisdiction. A federal court can hear a civil lawsuit because the plaintiff is a resident of a different state than all the defendants and her claims are alleged to be worth more than $75,000. Unlike federal question jurisdiction where there's no minimum, there is a minimum monetary requirement with diversity jurisdiction. For example, suppose a Kansas plaintiff wants to sue a Missouri defendant in federal court under diversity jurisdiction for a defective car. She can do that because she is a Kansas resident and the defendant is a Missouri resident as long as her claims are worth more than $75,000. However, if that Kansas plaintiff wants to sue both a Kansas resident who sold her the car and a debt collector from Missouri for hounding her to pay the car note on the defective car, she cannot use diversity jurisdiction because she is a Kansas resident and one of the defendants, the one who sold her the car, is also a Kansas resident. That means there's no diversity jurisdiction because one of the defendants is from the same state as the plaintiff. Even though one of the defendants is from a different state. All of the defendants must be from a different state than the plaintiff. Now we're going to talk about venue. Venue is different than jurisdiction. Venue is simply the geographic location of the trial, where the trial is going to be held. Once a case is filed, once it's in the court system, venue rules determine where the trial will be held. Usually the county of residence of the defendant, or the plaintiff in some circumstances, like if there's an out-of-state defendant, is the venue for the trial. Venue can also be established by the location of the property if the property is at issue. For example, suppose a bank wants to foreclose on a house because the defendant hasn't paid the mortgage. The county where the property is located is the county where the foreclosure action will be filed. Venue can also be determined by the location of the incident concerning the dispute, like the place a car accident happened. Suppose there is a car accident here in Sedgwick County. Somebody rear-ends another car and the plaintiff is injured. The plaintiff files suit usually in Sedgwick County where the accident occurred. The plaintiff chooses venue when he or she files the case. Now, the defendant can seek to change venue via a motion if the venue is inconvenient or the defendant believes a fair trial is not possible in that court. The judge has wide discretion to grant or deny motions to change venue. You see motions to change venue more often in criminal cases, particularly if there's been a lot of publicity concerning the crime, because the defendant believes that the jury pool has been influenced already by the adverse publicity in the case and will be more likely to find him guilty just because of what they've seen on the television. You see motions to change venue more often there than you do in civil cases, although there is the ability to change venue in civil cases as well. Now we're going to talk about state courts. Here's your overview. State courts are the oldest courts and predate the U.S. Constitution and the creation of federal courts. There were courts in the original 13 colonies, like Massachusetts and Pennsylvania, long before the Revolution. And certainly they predate the Revolutionary War when we became the United States afterwards. Earliest state law opinions in the original 13 colonies often referred to English common law. English common law is the basis of the law in the United States. It's one of the sources of law that we discussed in Chapter 1. Common law is a body of law developed in England and primarily from judicial decisions based on custom and precedent, and they're unwritten in statute or code. We talked about precedent and how important that is, that previous decisions can influence and form the basis of current decisions in courts. The judges like to have a precedent to rely on because they don't want to make a decision in a vacuum. Common law constitutes the basis of the English legal system and of the legal system in all of the United States, except Louisiana, where laws are based on the Napoleonic Code. They're based on the Napoleonic Code because Louisiana was a French colony for so long. Common law is embodied in case law decisions, both published and unpublished. Although currently now, even unpublished decisions are available online from the court. They're truly not unpublished in the sense that they're not available. They're just not able to be used as precedent because they're not quote unquote published. Now we'll discuss the structure in general of state courts. The Constitution and the laws of each state establish the state courts. A court of last resort, usually known as a Supreme Court, is usually the highest court, although not always. They have different names depending on the state. For example, Texas has a Supreme Court, but it is for only civil cases. And then they have the Texas Court of Criminal Appeals, which is the court of last resort for criminal cases. It's due to the volume of cases they have in Texas where they've split civil courts of last resort and criminal courts of last resort. Some states also have an intermediary court of appeals. Kansas has one, most states do. Not all states have an intermediate court of appeals. For example, West Virginia only has a West Virginia Supreme Court. They do not have an intermediate court of appeals. Below the appeals courts are the state trial courts. Those are the courts of original jurisdiction where the lawsuit starts. States also usually have courts that handle specific legal matters like probate court, wills and estates, juvenile court, family court, small claims court, traffic court, etc. It's the bigger cities and the bigger counties with more volume that usually tend to establish more specific probate courts, juvenile courts, family courts. Like, for example, Wichita has all of those. But if you go out west, some of the counties do not have a specific juvenile or family court. They're actually handled in the trial court. It really depends on the volume and the size of the county as to how many of these specialty courts are created. Now we're going to talk about Kansas state courts. This is not in your textbook. It is only available on these slides, so make sure that you take good notes. This is our example for court organization in Kansas. We're a fairly typical state, so I think it's a good example of how state courts are structured. Kansas has municipal, which is city courts, that deal with alleged violations of city ordinances committed within the city limits. For example, Wichita has a municipal city court. These courts hear traffic and other misdemeanor offenses only, like littering, jaywalking. You can be represented by a lawyer in municipal court, but there's no jury right. It's a bench trial only. The judge is both the fact finder and the judge from the legal perspective. You do have an appeal right, but it is to the district trial court. District courts, like the Kansas appellate courts, are created by the Kansas Constitution, Article 3. It mirrors the U.S. Supreme Court, where the judiciary is created by Article 3 of the U.S. Constitution. These are the trial courts of original jurisdiction in Kansas. So let's talk about district court in Kansas. As trial courts, district courts have general original jurisdiction over all civil and criminal cases, including divorce and domestic relations, damage suits, probate and administration of the estates, guardianships, conservatorships, care of the mentally ill, juvenile matters, and small claims. Pretty much everything that isn't exclusive federal jurisdiction can be brought in district court. Both criminal and civil jury trials are held in district courts. Kansas has 31 judicial districts with varying numbers of judges in each district. It depends on the population and the volume of cases as to how many judges are assigned to each district. There is a district court in each county and an office of the clerk of court where cases can be filed. Appeals are to the Kansas Court of Appeals generally. Now let's talk about the Kansas Court of Appeals. The Kansas Court of Appeals is an intermediate appellate court. It hears all appeals from the district courts in both civil and criminal cases, except those which may be appealed directly to the Supreme Court. And that's a very small number of cases. The Kansas Court of Appeal also reviews state administrative actions as provided by law. The court can hear appeals en banc, which is all 14 judges, but the court usually sits in panels of 3 and may sit anywhere in the state. Most often you're going to get a panel of 3 and then you can ask for an en banc review, but they don't have to give it to you. Now let's talk about the Kansas Supreme Court. The Kansas Supreme Court is the Kansas State Court of last resort. It's our highest court. It hears direct appeals from the district courts in the most serious criminal cases and appeals in any case in which a statute has been held unconstitutional. You can get a direct pass from the trial court to the Supreme Court if the trial court declares something in the Kansas Constitution unconstitutional. They also will take immediate appeals for death penalty cases. It may review cases decided by the Court of Appeals and may transfer cases from that court to the Supreme Court. It also has original jurisdiction in several types of cases: mandamus, habeas corpus, quo warranto. It's very rare, and most often you're going to see appeals from the Court of Appeals to the Supreme Court. Now you notice that I put may review cases decided by the Court of Appeals, because the Kansas Supreme Court, you don't get an automatic appeal to the Supreme Court. You only get one appeal of right, and that's to the Court of Appeals. You have to file a writ of certiorari to get the Supreme Court of Kansas to take your case, and it's not automatic, and they don't take every case. 7 justices sit on the Kansas Supreme Court. That's unlike the federal Supreme Court, where 9 justices sit. Now we're going to talk about Kansas judicial selection, how judges are selected to serve in Kansas. Judges for both appellate courts, both the Supreme Court and the Court of Appeals, are appointed by the governor from a list submitted by each court's respective nominating committee, which is made up of lawyers in the state. If you want to serve, say, on the Court of Appeals, there is an entire nominating process. Someone has to nominate you to get you on the list, and then the nominating committee reviews all the applicants who've been nominated, and they usually narrow it down to 3, and then they send that list to the governor, and the governor chooses the new appellate judge from that list of 3. However, in some states like Texas, appellate judges are elected. There's pros and cons to having appellate judges elected. I think having judges campaign gives an appearance of impropriety, sometimes particularly if they've gotten money from large corporations who then appear before them. But there's also the view that the people should have more of a say in who serves as a judge to decide cases over them. So there's pros and cons to each system. In Kansas, voters vote to retain appellate judges for every 6 years. You don't vote to elect the judges, you vote to decide whether they can stay on the court. If you've ever voted in Kansas, there'll be a section that says, do you retain Judge so-and-so on the Kansas Court of Appeals? Yes or no. District court judges in Kansas are both elected or appointed by committee depending on the county. 17 counties do appointments. Sedgwick County judges are elected. Nationwide, the trend does seem to be to push for judicial elections, though appointments are also still common. Municipal judges are appointed by the city in Kansas. So, for example, municipal court judges in Wichita and Sedgwick County are appointed by the city council. This is the end of part 1 of chapter 3.